So what is a corporation? Well, we're going to spend a fair amount of time exploring the answer to that question on many levels. But it's helpful to start with some basic ideas. So firstly, corporations are creatures of state statute. Now, what does that mean? Well, it means that unlike a partnership, as we saw, it's not something that gets created by accident. It is not something that is recognized by or comes from the common law, but rather it required some legislative action, some adoption of a state statute before such a thing could be created. You are relying on the authority of a legislature before you can create a corporation. Now, in the United States, the legislatures that are allowed to do that are states. There is no federal corporate law, or at least no federal incorporation statute. And so corporations are creatures of state statute. You are a Delaware corporation, a Pennsylvania corporation, a New Jersey corporation. You can also be a Cayman Islands corporation, a German GmbH or KG or so on. There are corporate entities that are also enabled or created by different jurisdictions outside the United States. But in terms of U.S. law, we're focused on state statutes. Now, which state? In most cases, people pick one of two choices. They either pick the state in which the business is primarily located. So if you're going to start a pizza parlor in Pennsylvania and you want to use the corporate form, you're going to choose either Pennsylvania law, because it's usually simpler and actually cheaper, or you're going to choose Delaware. Many corporations, no matter where they're located, no matter where they run their business, are Delaware corporations. To a lesser extent, people pick California, and to a lesser extent than that, probably New York. There's some reason people like Nevada, but vast majority are going to pick Delaware if they aren't picking the state where they are operating, right? So even businesses that are being built in Silicon Valley are primarily formed as Delaware corporations. And the reason for that is that Delaware has such a long history of being the place where people decided to form their corporations that it has such a well-developed statute, such a well-developed common law around that statute, interpreting that statute, such a highly expert court and judiciary that interprets those common laws and those statutes, that people are most comfortable forming their entity in Delaware and subject to Delaware law because the law there is so predictable. And also, some people say, most management friendly. But whatever the reason, Delaware law is often the choice for where you're going to form your corporation. We also hear often people say of a corporation that it's a fictional person or a legal person. And what do they mean by that is that like a person, corporations can do certain things that you would imagine normally could only be done by living, breathing things. So corporations can own things. They can own real estate, right? They can employ people. They can lease stuff. They can, in effect, engage in the things, the operations, the activities that make up a business. And you say, oh, well, how's that possible, right? They don't have mouths, they don't have arms and legs. And, well, they do it, obviously, through the arms, mouths, and legs of their agents, their employees, their officers, etc. But from a legal point of view, they are living, breathing things that are the body, the entity, the creature that is the one that is doing things, owning things, selling things, etc. We even go so far to say that they have rights as people. So there was a Supreme Court case, Citizens United, where they overturned some restrictions on campaign contributions that the government was trying to impose on corporations who were spending money influencing political campaigns. And the reason that it was overturned was the Supreme Court said, well, corporations are people too, and therefore they actually enjoy First Amendment rights, right? So, but I think it's more important for our purposes, it is important to focus on this notion of a corporation as a separate person, as able to exist out there in the world as a thing separate and apart from the people involved, because not so much the metaphysical reasons that this sort of fictional person idea raises, but more because it is this separateness, this personhood, that underlies many of the structuring opportunities, the planning opportunities that a corporation allows us to engage in as corporate lawyers. So why are corporations important? Why are they the primary dominant form of business organization used in businesses, especially larger scale businesses? Well, I already alluded to this notion of separate assets and operations, right? So what is attractive about a corporate entity is it allows you to separate the content, if you will, of a business. The assets and liabilities that are associated with that business, the operations, the people, right, can be put into a separate single box and distinguished from the assets either of the owner himself or herself or themselves, or from the assets and liabilities and operations of a different business that is not otherwise involved. So imagine a world where it was not possible to distinguish Apple from Steve Jobs, or to distinguish Apple from the folks that manufacture the cases that you put your iPhone in, right? Imagine where there was no way of having those things be separate from the people involved in the activity, right? And how hard to imagine that could be, and what an inhibition on the creation of these enterprises that would have been if everything had to be mixed together and couldn't be held in these separate buckets, right? The other nice thing about a corporation is it doesn't have to die. It is a person, but it's an immortal person if it wants to be. The assumption in a corporation is that it will last perpetually, right? So even if its founders, its owners, its managers, etc., like Steve Jobs, pass away, the corporation continues, right? It can last forever in theory, although they rarely do. Limited liability. This is something we've already talked about quite a bit, but one of the privileges, if you will, that comes from the statutory backdrop for a corporation is that the legislature has given the owners, the shareholders in this case of a corporation, the status of having limited liability. And what does that mean? Well, basically, in shorthand, it means the most you can lose is the amount you've invested. If there's something that happens inside the separate assets and operations, inside the business itself, inside the box, that problem, that liability, that obligation cannot be extended up through to the owners themselves, right? The most they can lose is what they have in the box, not come after their homes or their other businesses on the other side. It's all cabined, right? Obviously very attractive as a way of enabling people's willingness to make certain kinds of investments. I mean, imagine a world where if you wanted to build a railroad, your only choice was to have personal liability for whatever accidents happen, right? Who would ever involve themselves in a railroad if that was the downside, or the cost is that you had to accept joint and several liability for accidents? No one would have ever built a railroad. So one of the byproducts of limited liability, and one of the attractions of the corporate form, which uses things called stock or shares as a way of representing ownership, is how those two things engender a possibility for there to be both dispersed owners, meaning you can have multiple people have an economic interest in this separate group of assets and operations called the corporation, the business, right? So unlike a partnership, which tends to be a cohesive group of people, a close-knit group of people who are not relatively disinterested and not very liquid in their ownership, right? So in a partnership, remember the default rule is you can't transfer your partnership stake without the consent of the others. The assumption in a corporation is that your shares are freely transferable and readily liquid. In other words, that it's easy, should be easy for you to be able to go, if you can find an interested buyer, to just transfer your shares. And now they stand in your shoes as being an owner in the enterprise. And that the facility of being able to do that allows for the development of a more robust, more liquid capital market, right? And why is that? Well, relatively easily transferable shares allow people to be relatively passive in their investments. What does that mean? Well, if you are locked into a deal, right? In other words, your only way to make money on a deal is to stick it out. You will have an incentive to spend more time managing the underlying enterprise, right? You want to be much more involved in something that you're stuck in, all right? Whereas if you can vote with your feet, as corporations are designed to allow you to do, in other words, if you can vote by saying, I'm not interested anymore, I'm selling to the next person, you can be comfortably, much more comfortably passive in the way you participate in the management of the enterprise, right? And it is clear, when you think about it, fairly obvious that the more you have to be involved, the less of those types of investments you can have, right? Whereas if you can be relatively passive, it's possible to have more and more positions in different enterprises because it doesn't take that much work to monitor your investment, right? And so this looks much more like a market, a stock market, whereas partnerships look much more like private little businesses where people are, much more heavily involved in the underlying enterprise. So without the corporate form, this kind of stock market type dispersed passive ownership wouldn't have arisen. And what having multiple positions allows someone to do is it allows them to be more diversified, right? And therefore to take more risk, right? Because a more diversified portfolio is a portfolio that can withstand more losers relative to the number of winners. If you can only have a handful of positions, it matters a lot more to you if one of those positions turns out to be unsuccessful, right? And so the rise of modern capital markets, the rise of venture capital, the rise of a willingness of investors to take equity risk in new ventures or in established ventures is a byproduct, or it was a prerequisite to that development that the corporate form exists. And so that's one of the biggest reasons why corporations are such important forms of organization in modern society. And the other aspect of that is it also allowed for and made much more common the separation between owners who now can be passive and professional management, right? It's no longer necessary that the people who run Apple also be the people who put the money up, right? Because it's not necessary for you to be active. It's possible for you to be a doctor or a dentist who's investing in some tech startup, right? And so now tech startup people who have that expertise, can start businesses without necessarily themselves having the money that's necessary in order to own them, right? And that development further expanded the economic opportunity for society. At least that's the idea. Okay, so that's the what, the why, and now to the how. How do you create or form a corporation? And to give you a quick overview, there are 4 critical steps. To initially create a corporation, you have to file something called a certificate of incorporation. That's what it's called in Delaware. In other states, they're called articles of incorporation. And then generically, we sometimes refer to this document as the charter. But in every case, in every state, the way you form a corporation, as we'll see in a second under the Delaware statute, is to file this piece of paper with the state and pay a fee. Then the next step that you usually take is to adopt bylaws. Bylaws are also required by the state statute in order to legitimately form your entity. The third step is you elect a board, and we're going to talk about what a board is in more detail a little later, but basically this is the group of people, and it can be as little as one person, but often a group of people who are charged with the overall responsibility of managing the affairs of the corporation. And primarily their job is to elect officers who are the people like the president or the vice president or the secretary who conduct the day-to-day affairs of the entity. All right? And so we're going to talk about the different constituencies that make up a corporation. They like shareholders, board members, officers, and their relationships with each other. But to start things off, to have a head, if you will, on the body of the corporation, you have to elect a board. And we'll talk about how that happens. And then finally, while it is not required in order to form your corporation, and you can have a corporation that has never done this, in most cases, you're going to issue shares, sometimes also called stock, right? So common stock, preferred stock, whatever kinds of stock, you're going to issue stock or shares, and you're going to do that in order to represent or evidence ownership interests, both economic and managerial or voting rights with respect to the corporation to whoever the people are who are the owners of the entity. Okay? So those are the four things that we're going to look at: filing the certificate, adopting bylaws, electing a board, and issuing shares. Okay, so I said that the first step in forming our corporation is to file the certificate of incorporation or the charter. And where do I get that requirement from? Well, let's look at an example of a state statute, in this case Delaware, and see what it says, right? So here's Delaware, and I'm looking at the first chapter and called Formation, the very first section, and it talks about what is necessary in order to form a corporation. And it says, anyone can do it by filing with the Division of Corporation in the state of Delaware a certificate of incorporation, which shall be executed in knowledge, blah, blah, blah. Okay? So here we see that the first step in creating a corporation is the filing of this thing called a certificate of incorporation. And then there's some details about what the certificate has to include, which we'll get to in a second, but it's worth a read. And then some more details about how you actually have to sign it, who signs it, blah, blah, blah. Okay. So, but besides looking at the statute, and you should, question is, okay, well, how mechanically do you actually do this? So here's an answer. No, I'm not looking for LegalZoom. I'm going to look for the Delaware Secretary of State. That's the entity within the government at Delaware that is in charge of corporations. I click on their website, get corporate forms. I'm going to pick a domestic corporation, which means that I'm forming a corporation that's home, its residence, its situs is going to be in Delaware. It does not, though, require, and we're going to talk about this in a second, that it actually be physically located in Delaware. In fact, most Delaware corporations have no physical presence in Delaware. They have a presence, and we'll talk about that in a second, but they don't have an office there or anything like that, which is interesting. But here we go. And then we're going to form a stock corporation, which is the typical one. It's the most common. And lo and behold, the state provides us a little instruction letter that basically says, hey, once you file a thing called the Certificate of Incorporation and pay us our fee, which is $89 for the first page, with a little extra for extra pages, so it pays to be concise. We file that along with a cover memo, giving them some contact information, and boom, once it's filed, assuming it complies with their requirements, you have a corporation. They're even nice enough to provide us with a fill-in-the-blank form for the certificate of incorporation, giving us, some blank spots to fill in. And we're going to go through those in a second. But once you've done that, signed it, and shipped it in, and paid the fee, assuming you filled it in correctly, you're golden. You have a corporation. But I'm not going to use this form. I'm going to use a slightly fancier form, a little more complicated form that's provided by Practical Law. Okay, so here I am looking at a certificate of incorporation for Our House, Inc. That's the entity that we're going to form here to own the house. And you'll notice if you compare this form to the form that we found on the state's website, it is remarkably similar. Each of these provisions are provisions that are either mandatory under the statute or in a couple cases have become best practice. But let's go through it pretty quickly. So obviously the first thing we have to do is give our corporation a name. The statute will tell you it can be any name provided that it includes something like the concept or the phrase Inc. or Corp. Or company, indicating to the public that what we're talking about is a corporation. But otherwise, then you're free to use any other name in front of those letters. The only restriction is, of course, that no one else can have used the same name. So the trick is to make sure that your name is both unique, which is an issue you have to think about relative to trademark, not corporate law, but trademark. But also, you want to make sure it hasn't already been used. And there's a whole process you can actually go through to check that before you file so that you don't end up filing on a name that they reject you for. But actually, most people, what they do is they simply do a quick search on the Delaware website, and you can search to see whether or not a name has already been used. And assuming it hasn't, you can pretty safely bet that no one will jump in front of you. Then you have to indicate the address of your registered office in the state of Delaware. Now, I said earlier that you are not required to have a physical presence in Delaware, so you don't have to have an office, but you do have to have a registered agent, right? So you need someone who is resident in Delaware who you have agreed can accept mail, but most importantly can accept service of process on your behalf in Delaware. This is how you subject yourself to litigation, to suit, to jurisdiction in the state of Delaware, and that's probably the most important part about being a, quote, Delaware corporation. You can get sued there, and so most people pick one of these entities, and CT Corporation is by far probably the most popular. You'll see that probably hundreds of thousands, if not millions, of corporations have their office at 2711 Centerville Road. If you go there, it's a building, and all those offices are entries in a computer. But that's required that you have a registered agent. If you were actually physically resident in Delaware, you would not have to appoint an agent. You could simply use your address, but that's very rare. As provided in the statute, you must specify your purpose, but you can also specify that your purpose is any purpose that's lawful, and that is the standard approach. Why take the risk that you write something that puts you in a situation where what you end up doing isn't covered by what you wrote here? So most people just put, I can do anything the law lets me do. Here you have to specify how many shares of stock you plan to issue. This usually requires a little bit of thought, unless you're in a situation like this one where it's pretty simple. You can always amend your charter and change this, so you don't worry about it that much when you're forming the entity in the first instance. But hey, why pay the amendment fee? So if you know exactly what you're going to need in terms of numbers of shares, and we're going to talk about shares in a second, well, get it right. But in this case, I just put 1,000 as a placeholder. Here you put in the name of the person filing the certificate. Who's Jim Jones? Jim Jones can be anybody. Very commonly, Jim Jones is a paralegal at your law firm, or is some service provider who's doing this filing. Can be the lawyer, can be the person who's starting the company, Rose. It can be anybody, and we'll see Jim has a very limited job, even though Jim will show up forever as the incorporator of your company. That sounds fancy, but it really just means they filed a piece of paper, and they have no real role other than one, which we're going to look at in a second. And then the rest of these provisions are really optional, but they are recommended. I'm not going to go through them, but you can take a look at them and sort of start to think about why they might be a good idea, right? You'll notice they weren't included in the state's bare bones version, but that you'll see in PLC there's a discussion of what the theory is behind some of these optional provisions. It put me up to 3 pages. That's an extra $18, so probably I'd try to squeeze this in there. So that would pay extra $9. But in any event, there I am. That's my certificate of incorporation. I file that with the state, pay them $97 when I squeeze the signature in, and boom, I got myself a company called Our House, Inc. So once I've done that, what am I going to do next? Okay, what else do I need to do? I mentioned already, for example, that the next step would be to have bylaws. Okay, so here, the next piece of paper that you would see me create, I'm going to make it a little bigger, is called the Organizational Action of the Sole Incorporator. You remember him? That's our famous Jim Jones. Okay, and so what is Jim going to do? Jim is going to sign this piece of paper, and that's going to be Jim's last act on behalf of Our House, Inc. So he incorporated us, and now he's going to immediately after that sign this piece of paper, and then he's done, right? And in signing that piece of paper, he's going to do 2 things. He's going to adopt bylaws for the corporation, and we're going to look at those in a second, which because corporations are required by the statute to have bylaws. And then second, he's going to elect our first board members. And again, you saw originally that we said that the third step in forming a corporation is creating a board. So now we're going to take care of that. So Jim, our utility player here, is going to adopt bylaws and elect a board. But once he's done that, he's done his job, and now the company is run by the board. And so we have a board member who can now take actions on behalf of our company. So it's like, Frankenstein has come to life, and Rose is the brain, right? Okay. So that's the second thing we'll do, and we've gotten done our bylaws and our board. Right. So what are we going to do next? Next, that board that we created is going to do something. Okay, it's going to come to life and start being a board, right? Now, how's it going to do that? It's going to hold a meeting. Well, not really. It's going to be deemed to have held a meeting, because what it's going to do is it's going to meet by written consent. Now, this is a concept that you find in every state corporate law statute that says that if you can do something in person by meeting, in most cases you can also do it by pretending to have met, writing down what it is you would have done had you met, and then signing that piece of paper saying, I agree to deem to have done these things as if I had met. That's called a written consent. Now, sometimes to act by written consent, you have to act with more of a vote, more of a consensus than you would have needed if you acted by in person. So in this case, just to make sure we got our bases covered, we're going to act unanimously, which is of course pretty easy when you're only one person. But that's what we're doing here. And what is it that our board is going to do? Well, our board is going to belt and suspenders and say, hey, what Jim did on our behalf is ratified. We're going to approve it and make it formally the action of the corporation, including the filing of the certificate and the adoption of bylaws. Right? We'll look at the bylaws in a second. We're going to adopt our corporate seal, which is a vestige of the good old medieval times. Most people don't ever use it. but in any event, you're supposed to have a corporate seal. We're going to talk about how we're going to evidence our shares when we do issue them. We're going to confirm that we've elected Rose as our sole board member. And now, for the first time, we're going to add some, team to actually run the day-to-day affairs of the company. And initially, what we're going to do is appoint Rose as an officer. So she's both a board member, and now she's also an officer, which makes her an agent of the corporation who can enter into agreements and take actions. Now the arms, we have the head, the board, but now the arms and legs of our entity have been formed, and they are Rose. We're giving Rose actual authority to do things as our agent. We're doing it by authorizing her to enter into contracts, right? And then several other ministerial things, which, adopting our fiscal year, telling everyone where our real address is, blah, 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 right? And you can just peruse those and get a sense of the kinds of things that, sort of the first breath of our corporation consists of, okay? But again, we did all this by so-called written consent. So Rose didn't actually meet with herself. She's deemed to have met with herself because she wrote it down what she would have done and signed it, and that's good enough. All right. So we mentioned that the second step required, which we've seen now done twice, both by the incorporator and by the initial board of director action, was to adopt bylaws. Okay, so let's see if we can find some bylaws here. We have created some bylaws. Okay, now bylaws are long. If you were to flip through these and go, wow, this looks like pretty important stuff, right? All kinds of details about when meetings can happen, the power of directors, right? Power of officers, and so on. And yes, within bylaws, there are significant choices that are being made, significant powers are being conferred. If you were to ask yourself, well, what are the authorities of officers, right? This provision, by virtue of it being an adopted bylaw provision of the corporation, defines the express authority of the president, the CEO, and so on, right? But when you look through it, you'll find that a lot of this is pretty much, I don't know how to describe it, but it's fairly boilerplate kind of language, right? It's, hey, we're going to decide later, or it's just restating what the general corporation law already provides, and so on. So while it is an important document, it tends not to be a very momentous document in terms of posing significant issues for a client to evaluate and make a decision on. Most bylaws are adopted pretty much wholesale from the form. And while there are contexts and questions that require maybe a little bit more thought, generally not a lot of thought gets spent on bylaws. They're pretty plain vanilla. It's like policy statements or terms of use on a website. But in any event, there's a lot of good stuff in here that's worth reading and learning about what it means, but there's not a lot of big decisions to be made. So we're not going to spend a lot of time on it. Just realize that you need them. And most people pretty much use the form. So if you Google in Google Images the phrase separation of ownership from management, this is one of the graphics that you find, and I think it's a pretty good depiction of the different constituencies that are involved in this fiction called the corporation. And so let's go through it a little bit together. All right. So what we have are shareholders, the board. So shareholders up top, the board next, management below that, and employees below that. Okay. And so what's this depiction meant to convey? Well, okay. Number of things. So how do board members get selected, created? Well, we saw already in our incorporation documents that our incorporator picked our first board. So Jim Jones picked Rose Ramirez as the initial board. But on a going forward basis, the statute requires that boards be elected periodically by shareholders. And we can see that by looking at the general corporation law here, which talks about meetings of stockholders and has a requirement that stockholders meet at least once a year. And absent some other agreement or some other provision in the charter or bylaws, the assumption is that shareholders, when they meet, will have one vote for each share, and we'll talk about shares in a second. But one of the things that they're going to do at that shareholder meeting, and in fact, it's pretty much the only thing they have to do every year, it's pretty much the only thing shareholders are asked to do on a regular basis, and that is to vote for the members of the board of directors of the corporation. All right, so going back to our little schematic, where is it? We can see here, shareholders elect the board, okay, at a meeting held once a year, generally speaking. What is of the vote required? Well, you can change the requirement in your charter or bylaws, but if you haven't specified the requirement, the statute provides that at a meeting held of shareholders at which a quorum is present, and the general requirement, again, absent some provision to the contrary, is that you need a majority of your shareholders to be present and voting. Although I say present in quotations because you don't have to be physically present. You can vote by proxy. But in any event, participating in the meeting, you need a majority to have a quorum, and then the plurality of the people voting is necessary in order to to appoint someone to be the board. And again, you can change that requirement any way you like, pretty much, by agreement, and we'll talk about it in the future. The board then, as we saw again in the case of our incorporation documents, as we saw Rose in her initial minutes, right, in her written consent, her first action as a board, she created the positions of president and secretary, that's management, and filled those positions with herself. So periodically, whenever there needs to be a change or an addition, or someone's retiring or resigning, the board will meet, and their job is to pick who's going to be the officers of the enterprise. Right? Now, generally speaking, one of the most important functions of a board is to pick the officers, and in particular to pick the CEO of a company. And then to approve that person's compensation and otherwise monitor that person's performance as they are engaged in the job of running the business, right? So shareholders pick board, board in turn picks management and monitors management. Now, why that structure? Well, the theory is that shareholders who are dispersed, shareholders who may only have a small, relatively insignificant investment in an enterprise, have a collective action problem, right? It's not worth it to them as individuals to spend the time and effort it takes to do an effective job of both recruiting and selecting good managers, but also monitoring them. So what they do is they create this, and I love this word, synecdochic relationship. Go look that up. But basically they have representatives who stand in their shoes and who, because they're a relatively small group, and boards, as we see in the statute, can be as few as just one person, although generally you have a larger number of people, but usually not more than a dozen, even in the biggest companies, whose job it is to be actively involved with the day-to-day management of the company. And again, if we go to the statutes, we can see that one of the provisions says that the business and affairs of every corporation shall be managed by or under the direction of, that's probably more appropriate in most cases, of a board of directors, right? So the board's job is to manage the company, but not necessarily to manage the company on a day-to-day basis, right? That's the job of management. And we know that, especially in a larger enterprise, officers can't do everything. So in turn, officers then turn around and hire employees who are not necessarily officers, although they can be, and officers are certainly themselves employees. But these are the folks who report to management, who then in turn reports to the board. They usually don't have direct reporting obligations to the board, right? And in fact, the board usually is not involved in their hiring, except in rare cases. That's a job that's been delegated to management as part of their oversight responsibility. Okay, so that is the basic structure of how a corporation works, right? We have shareholders who are owners, whose really only managerial role is to elect a board who represents them. A board, which is a much smaller group of people who act in the stead of the shareholders, representing the shareholders' interests, and who have fiduciary obligations to protect the interests of the shareholders. In turn, hire a group of people called management or officers, right, who in turn report back to the board and who are monitored by the board, who then themselves in turn hire agents, more agents, whose job it is to do what it takes to run the business, right? That's your basic corporate organization.